All right, let's resume, shall we? As I indicated just before the break, our first two papers were on essentially courts wrestling with the problem of sentencing. However, legislatures have not been entirely inactive either, especially in recent years. So this session we're going to hear about two important and certainly very interesting legislative developments, very different developments, one at the federal level and another at the provincial level. So our first presenter will be Rebecca Moore, who is a policy analyst with Environment Canada, and will speak about something that I think most of you have heard about, but may not know in great detail, and that is the new environmental enforcement legislation, and it is very new, introduced by Environment Canada. And I'll turn it over to Rebecca. Thank you.
Hi, everyone. As Owen said, my name is Rebecca Moore, and I'm an analyst with Environment Canada working on the implementation of the Environmental Enforcement Act. I should note that the two presentations that came before me are a wonderful introduction to this topic, as they have laid out a lot of the issues in environmental sentencing and a lot of the thorny problems that we have to grapple with. And the Environmental Enforcement Act in some ways addresses some of the issues that have been raised in the presentations before me. So as we work through it, it'll be interesting to see what you have to say. So I'm here to talk about the Environmental Enforcement Act and the amendments that it made to the fine regimes and sentencing provisions of the 9 federal environmental acts that it amends, and the impacts of those amendments on environmental sentencing. As a general disclaimer, any opinions expressed are my own and do not necessarily reflect the views of Environment Canada or the Government of Canada. As an administrative note, I refer generally to the EEA throughout my presentation, and take that with a grain of salt, in that the EEA amends, as I say, nine federal environmental acts. So when I'm talking about a change that's been made by the EEA, it's a change that's been made to CEPA or to the MBCA or to the Canada Wildlife Act, for example. So, as an overview, the Environmental Act, as I said, amends 9 federal environmental acts. It changes it kind of clarifies the sentencing context, codifying the fundamental principles of environmental sentencing, setting out the main principles of sentencing, and providing a series of aggravating factors which the courts must consider in determining the quantum of fines. It standardizes fine regimes across all 9 acts, and it creates distinct fine levels for different types of offenders. It increases maximum fines, and it introduces mandatory minimum fines for specified offenses. It also standardizes and provides a wider range of court order powers across all 9 acts. So we'll work through some of those changes, and then we'll ponder a recent decision, and then move on to our conclusions. So I've listed the 9 acts that are amended by the EEA here. The ones that are in black, the amendments to the EEA are now fully in force. For those that are in blue, the amendments are not fully enforced. So while we'll be talking about the changes to the fine regimes and the changes to the sentencing provisions and court order powers, those provisions are not yet enforced for the Canada Wildlife Act, the MBCA, and WPREDA. And I've just noted there for your reference that the majority of the EEA was brought into force in December 2010. The changes to the fine regime under CEPA were brought into force in late summer 2012. So the sentencing context, and this has definitely been touched on by our previous speakers. But through the 1970s and the 1980s, the courts recognized that a special approach to environmental sentencing was needed. And you see the courts looking at the objectives and principles that are set out in the criminal law context. And you also see them developing principles and factors of their own. So some of the main criminal law objectives and principles that you see the courts evaluating are principles such as deterrence, denunciation and reparation, and principles such as proportionality and parity. And you also see the courts really kind of developing the principle of the protection of the environment and the importance of that in the regulatory context. And now and the courts also elaborated a series of environmental sentencing factors, which I probably don't need to belabor the point at this point, but Judge Stewart, who spoke earlier, set out a series of principles in United Kino which are still used today, and they have been built upon and adapted through a series of case law, and most recently in Taroko Industries by the Alberta Court of Appeal. Another thing to kind of consider in this context is that certain environmental laws at the federal level, at least more recently, have laid out some sentencing considerations. And I've listed some of those acts for you here: the AEPA, the MBCA, and SEPA. But what's kind of interesting to note is that while we have all of these kind of these tools available, the approach that's taken is not necessarily consistent in all cases. If you think about the fact that depending on the act that you're working under, the fine regimes are very different, and so the courts are trying to apply fit principles in very different kind of fine range contexts, and you'll see the courts kind of weighing which principles are more important in the environmental context, or which factors are more important. So what the EEA does is it very much speaks to those types of questions. So the EEA sets out the fundamental purpose of sentencing. And it specifies that the fundamental purpose is to contribute to the respect for environmental laws that have as their purpose the protection of the environment through the imposition of just sanctions. So the EEA is stating that is the main purpose. So you no longer have this question of is the protection of the environment paramount? Is deterrence paramount? The EEA makes that clear. And then what are the objectives of those sanctions? They are deterrence, denunciation, and cleanup or restoration. The EEA also sets out the main principles of sentencing. And those are that the courts should consider, or the courts actually must consider, increasing fines to account for every aggravating factor. And the amount of the fine should reflect the gravity of each aggravating factor. And now the EEA also sets out a non-exhaustive list of aggravating factors. And these are essentially a codification of the sentencing factors that you see in the case law with some modifications. Something that I think is very important that the EE does is it specifies that the absence of an aggravating factor is not a mitigating factor. So that's something that we'll want to pay attention to. So one of the overarching factors, sentencing factors, that you see the courts discussing in the environmental context is the nature of harm to the environment. And when they discuss this factor, they're discussing not only the extent of the harm, but also the nature of the environment that suffered the damage. The EEA essentially codifies these concepts, setting out that if the offense caused damage or harm or risk of damage or harm to the environment or environmental quality, to any unique environment, to human health, those are all aggravating factors. It also specifies that if the damage or harm is extensive or persistent or irreparable, that is an aggravating factor. And as such, the courts must consider increasing the amount of the fine. And so what's good to note is that this includes actual and potential damage to the environment. It also includes damage to exceptional environments. Now, this is in line with the case law where the courts have interpreted this factor as applying to actual harm and potential harm. And so the EA also makes it clear that fines should not be reduced on the basis that harm did not materialize. And this, again, is very much in line with the direction that the courts have taken, as they have indicated that but this, despite the fact that harm does not materialize, that's essentially lucky, and you don't get a break for that. So and this is basically in keeping with the overarching purpose of respect for environmental laws and protection of the environment, and it also supports the objective of deterrence. So the next series of aggravating factors that the EEA deals with, are factors that the courts have considered under the umbrella topic of culpability. And so when the courts are looking at culpability, they assess the intent of the offender, the foreseeability of the danger, and the ease with which the offense could have been avoided. The EA codifies these factors as if the offense was committed intentionally or recklessly, that is an aggravating factor. If reasonable steps were not taken to prevent the offense despite having the financial means to do so, that is an aggravating factor. And also any attempts to conceal the commission of an offense are an aggravating factor. So the EEA is making it clear that fines should not be reduced in the absence of intention or recklessness, and as they state that the absence of an aggravating factor is not a mitigating factor. And now this is unlike the approach that's been taken in the jurisprudence, where the courts very much state that the more diligent the offender, the lower the range of fit penalties. What the EEA is doing is basically stating that in the absence of an aggravating factor, that's neutral. You will not, the fine will not be reduced down if there was a lack of intention, and that's again in keeping with the purpose of respect for environmental laws and the protection of the environment, as well as the objective of restoration. And then other aggravating factors are the previous criminal record and past involvement with the authorities. This again is a codification of the court's sentencing principles. So if the offender had been warned of the circumstances that became the subject of the offense, this is an aggravating factor. And if the offender has a history of noncompliance with federal or provincial legislation, also an aggravating factor. And again, more aggravating factors are whether cleanup, restoration, or preventative action took place. So the approach that the courts have taken with respect to this factor is they've looked at these types of issues under the kind of umbrella of remorse. And so if someone has cleaned up promptly after an offense has occurred, or if they've taken prompt action to ensure that an offense does not take place in the future, the courts have interpreted that as a sign of remorse and have treated those as mitigating factors. The EEA takes a different approach. Essentially, it's stating that if you do not take prompt action to prevent, mitigate, or remediate the effects of the damage, or to reduce the risk of committing similar offenses in the future. That is aggravating. And so it's really making it clear that fines should not be reduced on the basis that cleanup or preventative actions were taken after the offense. Interesting to note, the courts consider other elements under this umbrella heading of remorse, such as whether an early guilty plea was made, or whether there was voluntary reporting. And these mitigating factors should not be impacted by the EEA, as they're not explicitly listed in the list of aggravating factors. Finally, the last aggravating factor added by the EEA is whether the offender increased revenue or decreased costs. This is, again, very, very similar to, or this is a codification of the sentencing factors set out by the courts. Interesting to note, though, that the EEA adds on the concept of intention. So if the offender intended to increase revenue or decrease costs, that is also an aggravating factor now under the EEA. The EEA also amends the fine regimes of the 9 acts it amends. So prior to the development of the EEA, each of the 9 statutes amended had different fine regimes. And the maximum fines on summary conviction between these 9 acts vary dramatically, and you'll see they range from $500 to $300,000. The maximum fines on indictment also range from $5,000 to $1 million. The mandatory minimum fine existed for only one subsection of one act, and that's 13 sub 1.1 of the MVCA. Other interesting things to note, for 5 of the statutes, there was only one fine range throughout the entire statute, regardless of the severity of the offense or the nature of the offender. So essentially, for those 5 acts, if you had a maximum fine on indictment of $1 million, the courts were trying to place every single offense under that statute. We're trying to assess apply the sentencing factors and try and determine the appropriate fine within that 0 to $1 million range, based on an assessment of the nature of the corporation, the nature of the offense, and that becomes quite a challenging situation. For 3 statutes, they had different fine ranges depending on the type of offender, so they had a little bit of a nuanced fine context. And for the CNPA, they have different. That act had different fine ranges depending on the severity of the offense. So, what were the problems here? The low maximum fines failed to reflect the seriousness of environmental offenses. The fine ranges tended to be very broad and applied to a broad range of offenders with diverse financial capacities. And they applied to a broad range of offenses that could be contravened by a broad range of activities that had a broad range of consequences. So with the enactment of the EEA, the EEA addresses these issues. It standardizes fines across all 9 acts. It increases maximum fines, and it creates distinct fine levels for different types of offender and different types of offenses. So, for different types of offender, the EEA sets out 3 different fine ranges: for individuals, for small revenue corporations and ships and vessels under 7,500 tons, and for other persons' ships or vessels. So this reflects the fact that the specific deterrence appropriate in a given situation depends on the financial capacity of the offender. And it essentially supersedes the sentencing factor of size and wealth of the offender. For those of you that are familiar with the sentencing principles that the courts generally take into consideration, one of them is typically the size and wealth offender, and they use that to try and place the appropriate quantum of the fine kind of within that general one-size-fits-all fine range. The EEA essentially removes the necessity of doing that. It's specifying the appropriate fine range for different types of offender. The EEA also sets fine ranges for different types of offense. So there are designated offenses that involve a risk of harm or harm to the environment or obstruction of authority, and those are subject to mandatory minimum fines and higher maximum fines. And then for all other offenses, so offenses that aren't designated specifically, there are no mandatory minimums and maximums that are higher than the old maximums but lower than the maximums for designated offenses. So where can you find the designated offenses? For statutory provisions, they are designated in the statutes themselves. So under CPA, the designated offenses are set out in the offense and punishment provisions of CPA. For designated regulatory provisions, they're found in regulations under the Act in question. So for a regulation under CEPA, there are, and I've listed them here for you, regulations designating regulatory provisions for the purposes of enforcement. And those regulations include a list of all of the regulatory provisions that are designated as having mandatory minimum fines and higher maximum fines upon prosecution and conviction. For the CWA and the MBCA, any provisions that are going to be, any provisions of the regulations are designated in, will be designated in the two regulations listed here. They've gone to CG1 in December 2012, and they are not yet in force. And so here then I've just kind of provided you a table that summarizes the new fine schemes, and you'll note that the maximum fines are substantially higher on summary conviction and indictment than they were previously. Also important to note that that both the minimum fines and the maximum fines double for second or subsequent offenses. I should also note, though, for the designated offenses, in situations where the mandatory minimums apply, the EEA has a safety valve. So the courts can impose a lower fine if it's satisfied that the mandatory minimum fine would cause undue financial hardship. The last item then that I wanted to talk to you about are the changes to the court order powers that are made by the EEA. So prior to the EEA, there were a range of court order powers which varied greatly between the different statutes. And CEPA had the greatest range of court order powers. The EEA standardizes court order powers across the 9 acts and introduces some new ones. So the EEA has made 2 court order powers mandatory. One, and it's the additional fine court order power, and it existed in several acts prior to the introduction of the EEA, but it was always discretionary. This is now a mandatory court order power. So the courts are required to order an offender to pay an additional fine equal to the court's estimation of any property benefit or advantage. And that is in addition to any other fines imposed and may exceed any maximum fines. So essentially what that does is that removes any economic advantage that an offender may have obtained through their activity, and returns them to their starting point, and then the fines would apply. Another mandatory court order power is a notification of shareholders. So the courts are now required to order corporate offenders with shareholders to notify their shareholders of the facts relating to the offense and the details of the punishment imposed. So that has quite a bit of deterrence value added there. The courts have also added, as I say, they standardized discretionary court order powers, and they've added 3 new discretionary court order powers across the 9 acts. The first is that they may order an offender to pay the Crown an amount of money for the purpose of promoting conservation or protection of the environment. And they may order the offender to surrender any permit or authorization issued under the Act to the minister. And they may also order the offender to refrain from applying for any new permit or authorization under the Act. So again, this has strong deterrent value, and I think if we look back to some of the comments made by Judge Stewart, this kind of relates directly to some of the choices that he or some of the suggestions that he put forward. So, are there any recent decisions then under the new regime? Ashford Cleaners is probably one of the cases that you are familiar with. It's been in the news quite a bit. And so essentially a Toronto dry cleaner was convicted of an offence under sections 4 and 5 of the tetrachloroethylene regs in July 2012, so just after the new fines under SEPA came into force. And so both sections 4 and 5 of the tetrachloroethylene regs are designated offences, and there are mandatory minimum fines associated with those offences of $25,000 for small revenue corporations. So, Ashford Cleaners was fined $25,000 for the violation of Section 4 and of Section 5, and they also received an additional fine as a result of having the aggravating factor of a history of noncompliance, and the fines went to the Environmental Damages Fund, which is now all fines under the new system now go to the Environmental Damages Fund. The offender Ashford Cleaners was also required to publish an article regarding the facts of the commission of the offence and the details of the punishment imposed. So, does this make a difference? If you look at previous convictions under the dry cleaning regs between 2009 and 2011, the fines tend to range from about $1,600 to $10,000. So this has definitely had an impact on the basis of this one case at least. But it's still very early to tell how the amendments made by the EEA will work. And as I said, the new fine regimes and sentencing provisions for the MBCA, the CWA, and WAPREDA are not yet in force. So, conclusions. For sentencing, the EEA identifies the overarching purpose and the main objectives of environmental sentencing, as well as key aggravating factors. It codifies the sentencing factors that have been set out in the case law as aggravating factors, and it specifies that the absence of an aggravating factor is not a mitigating factor. With respect to fines, the all-purpose fines are eliminated, and when I say all-purpose, I mean the fines that range from $0 to $1 million for every single offence under the Act. And so what you see with the advent of the EEA are standardized fines, higher fines, and fines that are tailored to both the offender and the nature of the offense. And then finally, the EEA also standardizes and increases the range of court order powers, providing a much larger opportunity for the courts to use creative sentencing to achieve the sentencing outcome that is warranted in the situation. So that's all for me. I don't know if anyone has any questions.
Thank you very much, Rebecca. We have time for some questions, and again, just hold up your card.
Yeah,
And,
if anybody has any questions in the room, just.
oh, there we go. And we'll also receive questions on the web, as I've indicated, at the email address. This is a very specific question. Do you know, or can you say, two different questions, I guess, when the Migratory Birds Convention Act 1994 amendments will come into effect?
I do know. They're at this point in time, everything, we anticipate them coming into force in 2015. But is our goal.
Okay. Another one, what factors drive the determination of whether an offense would be subject to the maximum or minimum fine regime?
Well, those are designated offenses, and let's see if I can go back here. So essentially, a policy, the policy test that was applied was, does this offense involve a risk of harm to the environment, or actual harm to environment, or an obstruction of authority? That was the basic policy test, and so if you look at it, in looking at a provision, if in committing a violation of that provision, there's a risk of harm to the environment, then the provision was designated, and it becomes subject to a mandatory minimum fine upon prosecution and conviction.
Are you aware of any recent decisions, including possibly Ashford, that have noted the new scheme, that is the EEA, and if so, did they discuss the new scheme in any detail?
I think Ashford is probably the biggest case that I'm aware of that has dealt with the new scheme. But we're beginning to see more and more cases coming down the pipes now. If essentially the new fine regimes for SEPA only came into force in June 2012, so you're starting to see the case law being developed and going through the courts now as a result of that. So I think it's still a bit too early to tell. But my hope is that we will be seeing more and more jurisprudence that really starts to analyze the new framework.
This has to do with a question with respect to one, I guess, aggravating factor. It was damage to exceptional or vulnerable environment. Is it or should it be relevant that defendant did not know, despite reasonable diligence, of the vulnerability, which seems to be a mistake of fact?
That's a good question. The position that the EEA is taking, and I think the position that we've seen kind of coming through the case law, is that when you're dealing with a public welfare offenses and the gravity of the offense and the responsibility of the offender are result from having committed that damage. The damage the damage exists regardless of the intention in some ways of the offender, and so I think whether it's a mistake of fact or not, that would be something that I'd have to think about a little bit more. But generally speaking, I think I would say no. Generally speaking.
Okay. Another factor that's mentioned is the availability of financial means as affecting whether or not aggravating factors apply. Does this open the question of whether you should be involved in the activity at all if you don't have the means to comply?
Well, I mean that is only a consideration for one aggravating when you're looking at any kind of anything within this realm, you're dealing with these are regulated communities, and you're engaging in regulated activities. That being said, the approach the courts have always taken to determining the amount of the fine is that it should be more than a slap on the wrist, but should not put a company out of business, essentially. To my mind, that's almost more of a moral question. I think the fines are certainly going to be higher from this point forward, and it should be something that people should take into consideration.
This is a question that actually ties into Judge Stewart's earlier talk, and it refers, I think, especially to the increased ambit of court orders here, the tools available. Do you think that, or was it intended that, the possibility of restorative justice will be given greater scope as a result of this act?
I think it's possible. I mean, there's a wider range of court order powers, and they're certainly there to be used. And I think that can certainly provide a lot more opportunity for restorative justice than we've seen in the past. So I certainly, the intent is to create a much more flexible sentencing regime that responds to the nature of the offense and the damage in a much more flexible way. And so hopefully we will really see those tools used and taken out.
And just finally, there's a policy question with respect to the Environmental Enhancement Act. Did Environment Canada consider other options for improving enforcement and enhancing enforcement, I guess, such as an environmental court?
That's a good question. I don't know. I don't have the answer to that. I didn't work on the project at that stage, but yeah, I just don't have an answer for that one.
Well, we will hear more about environmental courts this afternoon, so it's a good place to leave it then. I'd like to thank Rebecca on behalf of everyone here. That was, I think, for many people, a really good overview of a very new and interesting legislative regime. Thank you. Just going to get I said at the beginning of the session that there have been two, I think, very important legislative developments with respect to sentencing in the last several years, and that one of them was a provincial one, and it is an initiative that's been considered by a lot of provinces and has been adopted to some degree by many, perhaps most, and that is the use of administrative monetary penalties to improve both the efficiency of the regime and the speed at which it operates. And I think it's fair to say no province has been as ambitious in this respect as the province of Quebec, where you have both a very interesting legislative development, but also some real cases that have come out of it, so we can actually begin to see the evolution of that regime. And I'm delighted to have with us, because he was with us last year, and we appreciated him speaking on environmental prosecutions then, and he is the perfect person to address this. He is an active litigator, but also a prolific writer, and it is Jean Piette from Norton Rose Fulbright. Jean?
So, good morning, everyone. The purpose of my coming today is to discuss with you the new regime of monetary administrative penalties that has been established in Quebec by legislation passed in 2010, which came into force on February 1, 2012. I've written a paper on this, which is on the website. What I did today, though, is prepare a special PowerPoint. I drew from my paper a certain number of features which I thought would be relevant, would be the most interesting ones to present today. And also I've updated, because obviously I'm monitoring the evolution of this regime since it was enacted. So I've added some updates in my presentation. So I know I was offered to make the presentation in French, which would be natural for me to do so, but I know that if I did that, I'd be losing a certain number of listeners. So that's why I decided to make the presentation in English. So, by way of an introduction, we're going to talk about Bill 89, which is entitled actually Bill 89, Amending the Environment Quality Act in order to reinforce compliance. Those are the words of the amending statute. This was assented to on October 5, 2011. I'm sorry, it's 2011. I mentioned 2010. October 5, 2011. This amendment to the Environment Quality Act is an amendment to Quebec's fundamental environmental statute, which has been in force since 1972. So you have a statute which is out there, which is something like 40 years old, which has been amended tremendously throughout the years to take into account developments in the concerns of the government, developments in the knowledge of science, the knowledge of environmental impacts, and also new concerns of society with respect to environmental protection. For example, provisions were introduced to protect wetlands. Well, in 1972, wetlands were not really a big concern for the society. But as years passed, and new knowledge about the importance of wetlands in the protection of ecosystems, in the ecosystem, the balance of ecosystems, well, amendments were brought to the legislation to deal with protecting wetlands. Another issue was contaminated soil. Back in 1972, there was little concern and little knowledge about soil contamination, but as this developed, amendments were made to the Act. And so on and on, a number of changes were made throughout the years. Now, these Bill 89 really made some significant changes in the area of law enforcement. That was the concern of that statute. So the bill came into force on November 4, 2011, 1 month after having been assented to by the Lieutenant Governor, except for provisions concerning monetary administrative penalties, which came into force on February 1 of 2012. What actually Bill 89 does is provide a new regime of penal sanctions with increased fines and prison terms, increased penal liabilities for directors and officers, and increased powers for the court to issue remediation or punitive orders, somewhat on the line of what was adopted by the federal government in 2012. So there's a lot of similarity between the changes to the penal regime that were brought into force by Bill 89 and those that were brought into force federally. The Bill 89 also provides new motives why the minister may refuse to issue or renew or modify, suspend, or revoke an environmental permit. So you see here there's an effort to provide to the regulator additional powers with respect to the administrative mechanisms such as environmental permits that are provided in this statute. Also, the Bill 89 establishes a new regime of monetary administrative penalties, which we'll be talking about. Also, it provides a more effective process for actions of the ministry before civil courts. So the ministry has greater abilities to act before courts of civil jurisdiction. Also, there is an increase of the powers of the minister and of government to issue orders, so order-making power, and conduct inspections and investigations. So their powers were enhanced in those areas. Actually, Bill 89 purports to enhance the enforcement of the EQA and is a response to the perception that the penal process was insufficient to induce compliance and that the traditional notice of infraction system was in fact ineffective. Notices of infraction were notices issued by the bureaucrats to an individual who was caught doing something non-compliant with the legislation, the environmental legislation. These notices of violation are somewhat similar to the warning letters that Environment Canada issues routinely to ensure compliance with, for example, SEPA or the Fisheries Act. So what is the nature of a monetary administrative penalty? An administrative penalty is really a punishment for contravening a law. A fine or a prison sentence imposed by a court is also a punishment for contravening a law. So in both cases, both in the penal arena and in the, let's say, administrative or administrative penalty area, there is this idea of punishing a behavior which is not compliant with the law, with a regulation concerning the environment. So in both areas, the idea of punishing someone is present. Which means now that the EQA has two systems to punish contraventions. The regime of monetary administrative penalties applies to practically any contravention of the Act and of its regulations. I will deal with this further down in my presentation because you have here a mirror system. The administrative penalties, it's a mirror of the regime of penal sanctions provided in the EQA. And all the modalities of the regime are provided in the EQA itself. So the statute establishes all the modalities of the monetary administrative penalty regime the same way it establishes all the modalities of the penal sanction regime. For the monetary administrative penalties, 17 articles embody how the system works. It's important to notice that a punishment under these monetary penalties indeed may only be a fine or let's say a sum of money. No jail term may be imposed upon under such regime. If you look at the regime established by Bill 89, this system of monetary administrative penalties is somewhat comparable. I say somewhat comparable to similar regimes that exist under federal environmental law, and indeed this is now in force, and in environmental laws in Ontario, in Alberta, British Columbia, and New Brunswick. So those are jurisdictions that have adopted this system to a certain degree. The monetary administrative penalty, when we come to that, it's a penalty which is imposed by a civil servant. So there are bureaucrats within the ministry who have been authorized for this purpose by the minister. So it's not up to any of the 2,000 or so functionaries within the Environment Ministry to impose these sanctions. A certain number of individuals have been identified by the minister and have the authority to impose these penalties. The amount of an administrative penalty varies between $250 and $2,000 in the case of an individual, and between $1,000 and $10,000 in the case of a corporation, or in the case of, indeed, a public body such as a municipality. It is a system which is deemed to be distinct from the penal regime. To establish the distinction, it has its own vocabulary. So you see that the National Assembly, and the legislative draftsmen, when they drafted this new regime, they decided to use vocabulary which would distinguish the regime from the penal regime. For example, all throughout those 17 articles I mentioned, we only speak of a failure to comply or non-compliance. In other words, what is sanctioned is what is written down as being a failure to comply with the act, a failure to comply with the regulation, or non-compliance with the law. These are the words used in that section. Never is the word offense or violation used in that section. The word fine is never used either. And this appears to be in an apparent effort to establish a distance with the rights and freedoms protected by provincial and federal charters and bar constitutional challenges. So the aim of the National Assembly is to create a regime of penalty which is closer to a civil regime than to a penal regime. That is the apparent purpose of the National Assembly. It is a regime which can, to a certain extent, be compared with a regime of absolute liability in the penal area, except that administrative penalties are not imposed by a tribunal. There is no presumption of innocence. There are no prior hearings. And imposing an administrative penalty does not require evidence beyond reasonable doubt. As for penal sanctions, the National Assembly established 4 categories of administrative penalties, according to the seriousness of the non-compliance. In other words, the National Assembly took all the offenses, all the violations, all the non-compliance possible under the Environment Quality Act and its regulations, and they separated or established 4 categories. They put them into 4 different categories with different levels of penalties. The administrative penalty provided under the regime is always of a fixed amount, according to the category to which the failure to comply belongs. In other words, if, for example, a person causes an obstruction to the work of an inspector who wants to inspect the industrial premises, there is a fixed level of penalty. If this is a corporation, it's $2,500. So the bureaucrat who wants to impose a penalty has no discretion as to the amount of money he can assess. It's a fixed amount for any corporation, $2,500. The person receiving the administrative penalty receives no prior notice of the penalty and may not discuss the appropriateness of this penalty before it is imposed. However, a notice of non-compliance is required before the administrative is imposed. In other words, the way the system works, in the inspectors of the ministry, and there are hundreds of inspectors, go around, they visit an industrial site, they visit a property, they visit any place, where the act applies, and they write their inspection report. If they see something which is non-compliant, the bureaucrat will issue a notice of non-compliance. In other words, I visited your premises, I noticed you are not abiding by this obligation. For example, you're conducting an activity without a proper permit, or you have released a contaminant that you should not be releasing because it's beyond standards. So he issues this notice of non-compliance. So the person receives a notice saying that non-compliance has been found on his premises. There's also language in that notice of non-compliance saying, well, we may very well take penal charges against you, or we may very well assess an administrative penalty against you. So this is written in the notice of non-compliance. This is the only type of notification that the person receives. It's a notice stating that he has not complied with the law. And from there on, anything can happen. Penal charges, or nothing, or an administrative penalty, or in the worst case scenario, both an administrative penalty and a penal charge. It is possible, though, once you receive your administrative penalty, to request a review of the decision within 30 days. So you have that ability. You don't have the opportunity to discuss the penalty before it is assessed against you, but you do have the ability to ask for a review once you've received it. In other words, you've received your assessment, and you have 30 days to write a letter, and there's a form on the website of the ministry saying, I want a review of this penalty for a number of reasons that you state. The review itself is made by another person appointed by the minister. So it's another bureaucrat who will make that review. Such person must belong to an administrative division which is distinct from that to which belongs the initial decision maker. And this was an item which was mentioned during the hearings of the committee of the National Assembly when the bill was discussed, because originally there was not any mention of having distinct administrative units. And many people went before the members of the National Assembly and said, well, your system does not have any credibility. If someone a bureaucrat imposes a penalty, and it's his fellow next door who will review the penalty assessed by his neighbor, there's no credibility that there's going to be any fairness in such a system. So the idea was to establish a distance between the original decision maker and the review officer. The decision following a review is rendered after the applicant has had the opportunity to submit observations. So what you can do when you receive a penalty and you're asking for a review, you can submit observations. Those are the words used in the law. And you can also produce documents to complete the record. In other words, you can give the other side of the story to the review officer and say, the inspector didn't consider this, didn't see this, this is what we did, look at these letters, look at these documents, look at these analytical reports if you have any, or any other information. You have this ability to submit that information in writing to the review officer. The review officer, by the way, is never identified before you get a decision. You send your application for review to what is called a review bureau. So it's something rather anonymous, but you know there's a person who will do the review, an authorized person, and he will or she will sign on the review decision. The possibility of a meeting or of a hearing is left to the discretion of the person responsible for the review. So you don't have a right to a hearing, and this appears to be a rare occurrence. In, I'd say, 99% of the cases, you have to submit your evidence or your representations in writing. That's all you're allowed to do. A monetary administrative penalty is subject to 2 years limitations following the date of the failure to comply. In other words, 2 years after the event has occurred, the bureaucrat can issue an administrative penalty. Also, the 2 years can run from the date on which an inspection or an investigation that led to the discovery of the failure to comply has begun. So if a failure to comply occurs today, but a complaint about this is filed by a citizen 1 year or 2 years from now, and the ministry begins its investigation when it receives that complaint, then it has 2 years after it began its investigation to issue an administrative penalty, which means that the administrative penalty can theoretically come years after an actual event of non-compliance. The latter 2-day delay, though, applies only in 3 cases. In the case that false representations were made by a citizen, or in the case of a failure to comply which relates to hazardous materials, or relates to Section 20, which is the pollution prevention section, the duty not to pollute, no one shall emit contaminants in the environment that have detrimental environmental impacts or beyond established regulatory standards. Once you receive your decision from the review board or the review person, review officer, you have 60 days to challenge the review decision if you're not satisfied before an administrative tribunal, which is called the Tribunal Administratif du Québec. To this date, the administrative tribunal has rendered 2 decisions, each rejecting the challenge. So right now, as we stand as of today, and I made the check in the case law records yesterday, only 2 decisions have been reported. They were handed down and reported by the Tribunal Administratif du Québec. Each of those 2 decisions rejected the challenge. There may be 1 monetary administrative penalty for each day of non-compliance. This means when non-compliance is spread over many days, the total penalties may become substantial. There also may be, for a same event, as I mentioned previously, both a monetary administrative penalty and a penal prosecution, except in 1 case, except if the authorities decide to bring penal charges first with respect to a given failure to comply. So if the authorities decide this is so important it warrants a penal charge, the bureaucrats may no more impose an administrative penalty for this event. But if you go the other way around, if the bureaucrat imposes the administrative penalty today, well, he can refer the matter to the prosecutor, and a penal charge may be laid for the same offense 6 months, 18 months, or so many months or years later, depending on the statute of limitations, which applies to penal matters. And this statute of limitations is now 5 years. So the government has 5 years to lay penal charges. The government may provide by regulation monetary administrative penalties for non-compliance with any regulation enacted under the Environment Quality Act. So these penalties may be assessed for any violation of the Act, but also any violation of 36 regulations which were revised to introduce administrative penalties in each and every one of them. Here you have the table of the penalties as they exist now. You see you have these 4 categories. The first category, 115.23, refers to, let's say, minor offenses or offenses of a minor nature. For example, you filed a report late after the DLA, which is provided by regulation. So this is viewed as a minor offense. But the higher, the more serious offenses, For example, the fourth category, 115.26, these are the more serious matters. For example, emitting a contaminant beyond regulatory standards. That's viewed as a serious matter, and the higher penalties will apply for such situations. Today, violations of notices of violation have disappeared. So this traditional system, which had existed for decades in the ministry, that system of notices of violation has now disappeared, and no one issues such notices anymore. They're now replaced, as I mentioned previously, by a system of notices of non-compliance, which are now mandatory, the mandatory first step of the enforcement process of the Act and of its regulations. As I mentioned again, I come back to that, when an inspector notices that something is non-compliant, the first thing he will do is issue this notice of non-compliance. So these are hundreds of these, or I'd say even thousands of these, have been issued. They are issued on a daily basis. As I mentioned, the notice of non-compliance may be followed by a monetary administrative penalty or by penal charges, but the bureaucrats are under no legal obligation to do so. This is left totally to their discretion. The minister has prepared, as required by law, an enforcement policy for the Environment Quality Act. So the people that testified during the committee hearing said, you guys, these functionaries are going to have all of these wide discretionary powers that perhaps courts normally enjoy, but now bureaucrats will have all these powers. We want to have a better understanding of the circumstances which will bring the bureaucrats to act, to assess these penalties, or to bring penal charges. We want to have an understanding of your process, of your procedures, of the criteria you will use to determine whether any event of non-compliance requires a penalty, whether it be monetary or whether it be through the penal system. So the minister has prepared a policy. So this policy is accessible on the website of the ministry. It's something 7 or 8 pages long. It sets out the various violations that can occur, the various events of non-compliance that can occur. It establishes categories of non-compliance that are viewed as being minor, others that are viewed as being moderate, others that are viewed as being very serious, that perhaps require the highest penalties, and in most of these cases, penal charges. So this framework has been developed and has been published. It's an administrative directive. It defines the situations where administrative penalties are imposed and the situations where penal charges are brought. This framework is available on the website of the ministry. The framework certainly protects discretion of the bureaucrats, of the officials of the ministry, but nonetheless, you have these criteria. And when these criteria are used, you can always invoke them if you want to challenge, ask for a review of a penalty, or even challenge a penalty before the Tribunal Administratif du Québec. So it's a tool that defendants can use, even though it's not a law, it's not a regulation, it does not set rules of law. It nonetheless determines or establishes certain bounds for the use of the discretionary powers provided in the Environment Quality Act. It's interesting to note that directors and officers of a corporation which defaults on the payment of an amount owed to the minister are solidarily liable with the corporation for the payment of the amount due, unless they establish that they exercise due care and diligence to prevent the failure which led to the claim. Which means that if the corporation has been assessed a penalty, does not pay it, company directors and officers will have to pay those penalties, the unpaid penalties, unless that they have a kind of a defense here, a kind of a due diligence defense, which exists in the penal arena, except that here, since we're not strictly on the penal arena, that's another distinction. The legislative draftsman has used this concept of due care and diligence, and this is a concept which is codified in the Civil Code of Quebec. So that's why they're using that type of language instead of using the words due diligence or its French equivalent of diligence raisonnable. They use these words, due care and diligence, as I tell you, which are concepts which are part of Quebec's Civil Code, which are mentioned hundreds of times in the Quebec Civil Code as being the normal code of conduct of citizens when they deal with each other. Some of the features of the Quebec regime, as you see, in most other jurisdictions, monetary administrative penalties appear to have a support role in the context of the enforcement policy of environmental laws and regulations. Quebec's regime is universal, so it's not targeted on any category of industry, like Ontario's regime is targeted on the 115 companies which are mentioned in the regulation. Quebec's regime applies to everyone. It applies to any individual, any corporation, any municipality which fails to comply with any provision of the EQA. In contrast with other jurisdictions, where administrative penalties are often associated with agreements and commitments, that's a feature of the Ontario regime, but also in Alberta and BC, these penalties are associated with commitments to be taken by industry. The regime established in the EQA is really centered on imposing a punishment. That's what it wants to achieve. Monetary administrative penalties are now the basic instrument of the enforcement policy of the EQA. As of August 19, 2012, that's 6 months back, I wasn't able to update all of these figures, but at that time, a review of the registry of administrative penalties was made, and 416 administrative penalties have been imposed. 181 of them have been submitted for review. So you see there's a significant number of them, something like 40% of the penalties have been submitted for review. 17% of the penalties were canceled on review. So your chances of getting a cancellation of the penalty, you see, are not very high. 17%, that's the average. 9 penalties at that date had been referred to the Tribunal Administratif du Québec, and as of today, 2 judgments have been rendered. One question that you can legitimately ask yourself, are administrative penalties subject to the Quebec and Canadian charters? Administrative penalties are perhaps rather new in the environmental area, but they have been used extensively in other regulatory areas. For example, financial markets, securities, customs legislation. The various laws at the federal and provincial levels have provided for a number of years schemes of administrative penalties. So there have been cases that have gone before the court. There's the Wigglesworth case, which is one of the leading cases. In this case, the Supreme Court of Canada distinguishes penalties subject to the Canadian Charter of Rights and Freedoms and penalties that are not subject to the Charter. The Supreme Court said, if a law is designed to promote public order and welfare in a public sphere of activities, then we're talking about something which is closer, which is tantamount to a penal regime. And Section 11 of the Charter would apply. It does not apply, though, the court goes, to regulatory or remedial procedures which are private, internal, or disciplinary, or designed to maintain discipline, professional integrity, professional standards, or regulate conduct in a sphere of private and limited activities. So that's the view of the Supreme Court when it comes to assessing if these schemes of monetary penalties are subject to the Charter or not. When you look at the EQA, it's legislation of general application, designed to protect the environment and maintain public order and welfare in the environmental area by a system of statutory prohibitions and obligations which apply to all citizens, all businesses, all municipalities of Quebec, including government ministries, public agencies, and crown corporations. So everyone is bound by this law, which is certainly a law in the sphere of public activities. In the Wigglesworth, and in another case, a more recent case, the Martineau case of 2004, the Supreme Court establishes a test to verify if the regime of penalties is a penal process by its nature, or if the penalty has true penal consequences. In Martineau, the court mentioned 3 criteria to determine if a process is of a penal nature: the objective of the legislation, the purpose of the sanction, and the process leading to the sanction. Again here, the objective, when you look at these criteria and you want to apply this to this regime of monetary administrative penalties, the objective of the EQA is to protect the environment and the life, the health, and the quality of life of the people. When you look at the stated purposes of the penalty regime, of the administrative penalty regime, it's written is urging the person or municipality to take rapid measures to remedy the failure. So the law, this system seems to be designed, that's its stated purpose, to get rapid compliance with the law. That's why the regime has been developed, and it's written in those many words in section 115.13. And also, they mention deter its repetition. When you come to deter its repetition, you come to the principle of deterrence. Deterrence was mentioned as being one of the leading concerns or leading principles in the sentencing process in the legal, in the penal area. So you have something which is close to the objectives of the penal system, that is an objective of deterrence. And also, in the law, these 2 objectives are mentioned, but it says that these are examples. In other words, these are not exclusive objectives. There may be other objectives, non-stated objectives, and that's where I think the objective of imposing a punishment comes into play. Surprisingly, though, as I mentioned, the EQA does not mention that administrative penalties are designed to punish, even though the 2 stated purposes are not the sole purposes of the regime, and that's written in so many words. Even if the stated purpose refers to taking rapid measures to remedy the failure, with the existence of a 2-year statute of limitations and its almost unlimited extension when the delay is computed from the start of any inspection or investigation, it can hardly be said that the regime is really designed to achieve rapid compliance. The stated purpose of deterrence is also a recognized purpose of a penalty imposed in the context of penal proceedings. In the Martineau case, Justice Fish mentioned that stigma was also a relevant criteria. Stigma associated with a penal conviction was a big difference with an administrative penalty imposed under the Customs Act. When you look at the EQA, you have to come to the conclusion that the stigma of a penal suit and of a monetary administrative penalty are quite comparable, because both are registered in a publicly accessible public registry, providing detailed information for each and every monetary administrative penalty and penal conviction. In other words, any company that has had to pay an administrative penalty or pay a fine, these facts are in a public registry and are detailed. There are 10 items of detail that have to be provided with with respect to each and every monetary administrative penalty and each and every fine imposed through the penal system. You have again here mirror publicity, and the public, the competitors, the community is fully aware of any administrative penalty and any penal suit brought against a corporation or a citizen. So the level of publicity is equal in both areas. And both penalties are paid to the Green Fund. The government has established a Green Fund, and the administrative penalties and the fines all go in this Green Fund. When you look at the means of defense which are available to challenge an administrative penalty, when you read the law, you realize that the law does not provide any means of defense against any administrative penalty. And that's one of the reasons why people can view such penalty being comparable to a charge of absolute liability as determined in the Sault-Ste. Marie case of 1978, when the three categories, strict liability, mens rea, and absolute liabilities, were distinguished, were recognized at that time. So people can say these penalties, it's like an offense of absolute liability. You have no defense to offer. You can't offer any defense once the actus reus is proven, once the facts of the infraction have been established. You have no means of defense. However, when you dig further, you realize there is substantial case law from various courts in the country which recognize that a person has the right to invoke a due diligence defense to challenge an administrative penalty. Even though the law says nothing about it, the courts have said, and in a number of cases, that this exists, and this is in line with the generally recognized principle that any person to whom a penalty is imposed should have the right to invoke a defense where appropriate. We see, that's my view and the view of my colleagues in my firm, that there is no reason why the following means of defense, which are generally used by the courts of penal jurisdiction, should not also be admissible to challenge a monetary administrative penalty assessed under the EQA. So I look here beyond due diligence as other means of defense, error in the interpretation of facts or of a law or of a regulation, errors of a procedural nature, reasonable error of fact, which is close to the defense of due diligence, officially induced error, defense of necessity, of impossibility, de minimis, d'encourage lex, de minimis defense. So all of these are recognized defenses in the penal area, and we believe that these should also be admissible to challenge an administrative penalty. In the two known decisions rendered on an application to challenge an administrative penalty, the Tribunal administratif du Québec dealt with issues of fact and of law and came to the conclusion that a monetary administrative penalty was justified in each case. In other words, both applications were denied by this tribunal. Arguing a case before that tribunal is not really easy. It's an administrative tribunal. It's appointed by the government, its members. Is there a real distance between that tribunal and the administration and the bureaucracy of the government of Quebec? This question can be asked because when you go before the Superior Court, you know that you are arguing before a truly independent judge, a judge who is distant from the bureaucrats, distant from the administration, who is really free to review a decision made by the administration and quash a decision where appropriate if the rules of law allow them to do so. And this has been done in a number of cases. We've seen Superior Court judges quash regulations, laws as being unconstitutional, and so on. When you come before the Tribunal Administratif du Québec, the distance is not all there. So your chances of winning before that tribunal are not all that great. And that's both my personal experience and also the experience of others. So it remains to be seen, nonetheless, what other means of defense will be considered receivable by the Tribunal Administratif and by other courts if a matter is referred through judicial review to the Superior Court or appellate tribunals. Traditionally, the Tribunal Administratif du Québec reviews the reasonable character of administrative decisions. That's been the traditional scope of review which has been applied by that tribunal. Review, so now I was talking about the Tribunal Administratif. Now I come to the review decisions. So before going to the Tribunal Administratif, review decisions, when you survey those decisions, you realize that the review officers have accepted defense arguments contemplated in number 1, number 2, number 7 in the previous slide. So those defense arguments have been entertained and recognized valid, and the review officers have nullified some administrative penalties for such reasons. And there are indications that some form of due diligence may be acceptable as a defense argument. So we believe there is hope. I have myself acted in matters that are presently under review. I have submitted arguments of reasonable doubt and various arguments, or some of the arguments mentioned previously. I've even made an argument that a reasonable error of fact, like in the Chapin case, would be acceptable to have the administrative penalty quashed. I'm waiting for the decision of the review officer. Yes, here what I wanted to mention, and I'll end by this, is the duality, the fact that a same event can be punished 2 times. As I mentioned to you, this is something which is allowable in Quebec's Bill 89, except if the penal charge has been brought before the monetary administrative penalty. Most federal and provincial environmental acts do not allow that a same violation be subject to both a monetary administrative penalty and penal charges. That's what my review of legislation in other jurisdictions said. However, Ontario allows penal charges against a person who has already been subject to an administrative penalty. So this is a situation which is allowed in Ontario. The legality of a double punishment for a same violation could perhaps be challenged under Section 11H of the Canadian Charter of Rights and Freedoms and under Section 37.1 of Quebec's Charter of Human Rights and Freedoms. This may happen in the future. So to conclude, I wish to mention that Bill 89 indeed reinforces significantly the enforcement capabilities of the EQA. It marks a significant change of course in Quebec's environmental legislation, which can be used henceforth to impose rapid punishment for any event of non-compliance. There is certainly an increased risk of illegal challenges, considering the importance of possible fines, especially when a fine is or fines or penalties are assessed on a daily basis. The message that is sent to industry, businesses are under a strict obligation to comply with the EQA and its regulations. The businesses cannot count on ministry inspectors to, let's say, accompany them towards compliance or help them comply. The officers, the inspectors now act more like policemen than people helping companies to comply. And company directors and officers should take necessary measures to be able to submit a due diligence defense in penal matters, because now, I did not mention that, But now there is a provision in the penal area stating that any company director is automatically liable in the penal, before a penal court for an offense committed by the corporation of which it's a director or officer. So there's a direct association between the offense committed by the corporation and the penal liability of company directors and officers. But the law provides that the defense of due diligence is available to company directors, and they have to present a due diligence defense. Now, these are the words to be used for this penal liability. And if you're dealing with monetary administrative penalties, it's a defense of due care and diligence. And there's not a big difference between both. But this means that company directors and officers have to be much more conscious of their environmental liabilities, of their environmental responsibilities, and have to act accordingly in the decisions that they are to make in their capacity as a director or officer of a corporation. So that's what I wanted to share with you this morning.
Thank you very much. That was a great overview. We are over time, but we'll take us a few minutes in case people have questions. I know I have some questions, but before we get that question, Jean, I wonder if you could tell me that apart from the charter arguments, both Quebec Charter and Canadian Charter arguments, what's the scope for traditional judicial review for things like abuse of discretion for the person who issues this sort of thing?
Well, certainly I think the normal rules of judicial review would apply to this regime of monetary administrative sanctions. So a matter indeed, if a person is unsatisfied by the review decision and by the decision of the Tribunal de Justice du Québec, I would not be surprised if a matter was brought to the Supreme Court, the Superior Court, to upon an application for judicial review, saying was this reasonable, or in other words, if they want to attack the reasonableness of the decisions made by the lower decision makers, or if the person wants to challenge the legality of the whole system, the constitutionality of the whole system. Is it compliant with these provisions of the Quebec and federal charters?
And just on that last point, has there been a
No.
serious? There hasn't been.
No, not to my knowledge, not at its time. The system is rather new. It's about 2 years old, so I think you have to go through the normal administrative process before attacking a decision judicially. So will that happen? Will a person want to invest all the time, the money, and the effort to challenge it? It may happen, but we're not there right now.
Okay. The question from the web, is there a difference between due care and diligence versus due diligence?
Okay, it's an interesting question. I think certainly it needs to be further research, but my understanding, because I did do some research, is that these two concepts are rather similar. Because what I think the law requires in our free and democratic society is that what action should a reasonable person placed in similar circumstances take. It's always the behavior of a reasonable person, and a reasonable and diligent person. I say reasonable and diligent because the concept of diligence is there. So I think due care and concern has to be shown by a citizen who wants, a person who wants to invoke these means of defense. But I think they're rather similar, because when you're dealing in civil matters, or when you're dealing with respect to compliance with the law in the penal area, again, you have to be a diligent citizen. And that's what due diligence will recognize. Were you duly diligent to prevent the violation?
A question, apart from the review process for the penalty, does the EQA provide any specific review process for the notice of non-compliance, which seems to be the critical decision?
No, there is no review process whatsoever for this notice of non-compliance. there's nothing recognized as such. What happens in the real life, though, is that a person who receives a notice of non-compliance, if he disagrees with the evaluation made by the bureaucrat, will respond and provide immediately facts to either contradict what was found or determined by the inspector, or will take remedial measures immediately to correct the situation if the inspector was right. And indeed, I think this can be used perhaps to, let's say, deter the bureaucrat from imposing a penalty or sending the matter to the penal court. But it's only a hope that this will change the view of the bureaucrat, because actually the bureaucrat, and he writes in his notice of compliance, the fact that you will take remedial measures or correct the situation after you receive this notice of compliance will not be taken into account as to whether a nuisance monetary penalty will be assessed or penal charges brought against you or something. They state in so many words.
Just one final question, and this is, I guess, a practical question. Does this system essentially remove any possibility of dialogue between the inspector and the offender, if you will? And if so, does one can see the arguments for doing that in terms of essentially negotiating your way out of what you're required to do. But I would have thought in terms of the ability to respond quickly and in a way that is appropriate, it might limit options.
Yes, the system, because it's a strict system, it's you see how the system works, the various steps and so on. It does, I think, remove a space for dialogue indeed between the regulated person or regulated industry and the bureaucrats. Space for dialogue has been significantly reduced, and the purpose that wants to be achieved is more like acting as a police. In other words, they go there, they see non-compliance, you get the notice, a bit like the police does. They will send you a notice of violation, or they will send you a violation. You have to pay a fine and so on. They're moving in that direction. And let's say the dialogue between industry and the ministry is somewhat reduced by this approach. I'm not saying it's non-existent. I do speak with bureaucrats for every day almost, and we do discuss issues. But when the matter follows an inspection, the non-compliance was found, then the system starts rolling, and the space for dialogue is significantly reduced.
Okay. Well, thanks very much. I'd like to thank Maître Piette on behalf of everyone here and on the web. It was just a fascinating overview. And if you want a really detailed summary, I refer you to the paper, which is just excellent. So thank you again.
Thank you.